All right. Welcome, everyone. You are here for our bankruptcy webinar. We will cover some of the basic things that you should know about if you're considering filing for bankruptcy. We have David Berman with us today. He is a mentor for SCORE Boston, and he does do a lot of our legal-based webinars. So be prepared to learn a lot of information because I know he will be covering quite a bit for you today. As we get started, as a reminder, there's a couple of things that SCORE does. One is training through our webinars. You can find many of our webinars on our that we've already had previously recorded onto our website or our YouTube channel, and I can put that link into the chat here in a few moments. You'll also find all the upcoming events that we have. We have several new topics, so I encourage you to watch for the newsletter or to check out the website. The most important thing that SCORE does is mentoring. Mentoring is always free and confidential. Our volunteers come to us from all different backgrounds with different experience and knowledge to share with you. One of those topics could be bankruptcy, and we work also nationally through, so if we don't have someone in our chapter or in our district, we can also look through the national database to bring someone in to assist you. You do not have to already have your business started or have a business license to come talk to us. We talk to anyone at any stage of business or as a current business owner as well. A beginning session will be finding out what your needs and concerns are and what your goals are, and working on a plan to help you achieve them or solve the issues that you are having. Our mentors do sometimes work as a group. They will solicit advice from other mentors, or sometimes they will invite other mentors to join future sessions. If you don't have a mentor and you would like one, you can go to the score.org website, and there's a zip code box, and you can put your zip code in and submit a request, or you can go directly to any of the chapter websites listed here. While on those websites, you will find lots of information, so I certainly encourage you to take a look. There's templates and tools that you can download as well. So lots of great tips on there. I do anticipate we'll have quite a few questions today, so I want to keep them organized and not lose track of any. If you can put the questions into Q&A in the Q&A tab, if you want that question asked to the presenter, everything else can go into chat. And we are recording today, as a reminder, if you are just joining us. So we will have that link for you so that you can rewatch this presentation. Okay, I'm going to go ahead and pull this down, and I'm going to go ahead and turn it over to David. It's all yours.
Great. Thank you, Teresa. I'm just going to share a screen here so that we can go. All right. There's a lot of information here, and it is important, I think, that if you're considering bankruptcy, you talk to legal counsel. But bankruptcy in and of itself should not be your first option. It should be your last option, because when you get into bankruptcy, you can lose control, and other people are going to have a say, including a judge. But if you're thinking about bankruptcy, there are some things you need to do in advance. You need to engage professionals. The professionals would be an attorney and possibly an accounting firm if you don't have an accountant to help you, because there's a lot of information that you have to prepare and file with the court on a financial basis. You should work with your professionals to prepare a cash flow to show what the impact of the bankruptcy is going to be. And we'll talk a little bit later about things that need to be in the cash flow and don't need to be in the cash flow. For example, if you're in arrears with your landlord and you file bankruptcy, you don't have to pay that arrears on day one, but then you may have to put into your cash flow other things like paying legal fees and court costs and other expenses of the bankruptcy. So your professional can help you do that, because one thing that the court is going to look for in your bankruptcy, if you're trying to reorganize as opposed to liquidate, is going to want to make sure that whatever debts you incur after you file your bankruptcy can and are paid. They don't want to create more debt by virtue of your operating at a loss in the bankruptcy. If you're going to need financing, you should be talking to different banks, getting different proposals to get financing approved in a bankruptcy. You need to demonstrate that you've gone out and sought financing and that this is the best possible financing available. Not that it's a great deal, but it's the best available, that you've talked to lots of people. And it takes time to talk to lenders. They'll want to see your cash flows. They'll want to see other information about the business, assumptions that you're making. And so it takes time to line up a bank financing if you need a bank financing as part of the bankruptcy. Even if you have an existing bank when you're going into bankruptcy, you would want to talk with them to see if they'll continue to finance you in the bankruptcy and keep them apprised. Banks don't like surprises. Lenders don't like surprises, so you should be talking to them. Vendors. Generally, we take different positions with vendors. If you have a key vendor, you have one major supplier, you may want to fill them in and brief them. There are ways that you can protect them in the bankruptcy. The court could deem them a critical vendor, and in some cases, some courts would allow you to pay part of the arrearage that you do them during the bankruptcy, because most of the time the arrearages get dealt with in your reorganization plan, and you don't pay what's due pre-bankruptcy. But some vendors, you'll be able to do that. But most of your vendors in the bankruptcy are probably going to want cash and aren't going to give you a lot of credit. So if you're looking for credit, it's important that you keep the key vendors advised. Employees, crucial to consider your employees. There are some key employees that you won't want to see departing because you file bankruptcy, and you want to talk to them, keep them informed. You'll want to possibly offer them some bonuses if they stay on through the bankruptcy. Obviously, the bonuses will be subject to court approval, but you incent the key people to stay on. You don't want to file the bankruptcy and find all your senior management staff leaving. And I understand these are for small businesses, but if you lost your top salesman and you only had one salesman, one salesperson in your department, that would be potentially very harmful in the bankruptcy. And again, in employees, if you're in the middle of a pay period, we'll talk about one of the things you're going to do on the first day is to try to get the court to permit you to pay them for what they're owed before you file the bankruptcy. It's very important to note that when you file the bankruptcy, anything you owe prior to that date, you're not going to pay unless you get court approval or it gets part of the plan of reorganization. Utilities as well, they will have the right to require a deposit in the bankruptcy to assure performance. You may want to negotiate with them to make sure that that deposit is minimal or if you're lucky, non-existent. Reviewing your leases is important too. If your lease was terminated by the landlord before the bankruptcy for non-payment, then you really don't have a lease in the bankruptcy. But a lot of people who file bankruptcy may be in arrears in the lease, but the landlord hasn't terminated it. And so you'll need to pay your current rent after you file bankruptcy. You won't have to pay the arrearage at the time you file. You deal with that in your plan. But you need to know your lease status and whether you in fact have a lease or it's been terminated, and what your rights are in the bankruptcy. Timing of filing is something your professionals will talk to you about. There are a lot of companies that file, for instance, during the holiday season because they're cash rich then, and they have a lot of cash and they can keep the cash and use it in their business. And as opposed to going in at a time when it's a a season where they're not as cash rich and they need more outside support. We'll talk a little bit more about schedules and statement of affairs and first day motions, but all of this planning should happen to the extent it can before the bankruptcy. You know, when we talk about formulated general plan, I'm sure we all saw that Bed Bath & Beyond filed again the other day. Now their plan is they're going to close all their stores and liquidate. But in a previous filing, what they did was they cut their store number down from, I'm making up numbers now, to 500 to 300. And that was their plan, to try to close some stores and terminate some leases. And we'll talk about how all that goes along. But there's a lot of planning that goes into bankruptcy. I generally don't recommend that you wake up today and say, let's file bankruptcy tomorrow. It really, can be a month or 2 month long process, depending upon the complexity of your business organization. But once you get past that and decide that you are going to file bankruptcy, if I can get the next slide to come up, that would be good. Okay, this isn't working so well, but all right, let's see what we can do here. Teresa will get you all the slides in any event, but this is sort of frustrating. Let me see if I can make it a slide show here. Okay. All right, well, all right. So if you file a bankruptcy, the first thing the bankruptcy does is it stops all of your creditors from taking legal action, pursuing legal action against you, unless they can get a court order to do so. So if you have a landlord who has sent you a notice that he's going to sue you to evict you, and before he terminates the lease, you file bankruptcy, that suit is stayed. If you have somebody, to use an example from the past, the asbestos suits, where the company was being sued for all the asbestos damage, that stayed the suit. It stopped everything. The purpose of the stay is to give you a chance to take a deep breath and figure out how you're going to deal with things. And so the court doesn't want people pressuring you through legal action and collection action to deter your efforts from reorganizing. Obviously, the stay doesn't apply to certain things, like if you violate a criminal law, the police can still arrest you and prosecute you. But in general, for anything civil, they're stayed. And if they want to continue with their collection action, or if it's a bank foreclosing on a piece of real estate, they want to continue with the foreclosure, they have to go to the court and show the court, as I say in this slide, that there's reason to a good reason to let them go forward, or that there's no equity for you in the asset. In other words, the amount of the debt on the asset exceeds the amount that the property is valued at. So if you have a home worth $50,000 and the debt's $100,000, you have no equity. But they also have to show the asset isn't necessary for reorganization. So if you're in a manufacturing business, you have a piece of machinery that's worth $10,000 and there's a lien for $15,000 on it, they still may not get authority from the court to go repossess the equipment, because you need it as a manufacturer to reorganize. So those are key points. It's not automatic that the court's going to give somebody the right to continue to prosecute claims against you. And if you just own one piece of real estate, if you haven't filed a plan to deal with the real estate and the mortgage and paid some interest, the holder of the mortgage can seek relief from the stay. But note, this does not stop people from pursuing you on your guarantee. So a lot of leases of small businesses require the owner to guarantee. So the landlord can't come after your business, but they could still sue you on your guarantee. Obviously advice is try not to give personal guarantees. That's not always possible, but the creditors could pursue your guarantee, and there are some cases where the court will stay them for pursuing the personal guarantee too. That's not automatic. That's by court discretion, and they'll have to show good cause to want to pursue your guarantee if you're trying to stop them. Operational business. This is the first day. Once you get into bankruptcy court, you just can't run your business the way you want. You need court approval for certain things. For instance, we talked about paying your employees pre-petition wages. You can't just do that. You need to get court authority to pay them. Obviously, to retain your employees, they're going to want to be paid, and they're not going to care that you're in bankruptcy. If you're in the middle of a pay cycle, they're going to want to be paid for the portion of the pay cycle before the bankruptcy. Courts generally will allow that, subject to a cap. The court's not going to let you pay $500,000 to somebody for pre-petition wages, but most of your employees are going to fall within the cap. The second thing that your attorneys will do is they'll file something with the court to maintain your existing bank accounts. Technically, you're supposed to open a new bank account that says debtor in possession if you're in a Chapter 11 proceeding, and all of your business forms should indicate that you're in a bankruptcy proceeding in a Chapter 11. Depending upon the size of your business, you may have many bank accounts, and it may be a real pain in the neck to change them all. For example, if you were like in case I had Circuit City, where they were all across the country in different bank accounts in different states, that was a painful exercise. So I got an order saying they could maintain their accounts. But that will be something you'll have to do on the first day, because what the courts want to have happen is any checks that hit that account for periods prior to the filing of the bankruptcy will probably be bounced. And that's why they want a separate account. So everything that comes in the old account gets bounced, and the new account pays the new debts. Another thing you want to do is you want to pay your taxes. Once again, you're maybe in the middle of a tax period that you don't have to pay the withholding taxes. They're not due yet, or your sales taxes aren't due yet. But you'll want to get court authority to pay the taxes because one, you could be personally liable for them, even if you're an entity. And secondly, it's always good to be current with Uncle Sam and keep the taxing authorities off your back. So you can go to the court and ask the court to say, I'm in the middle of a tax period. I want to pay my withholding taxes that I owe, my business owes, as they come due, even though they were for some periods before the bankruptcy. Retail businesses in particular often issue gift certificates or gift cards. Once again, that's a pre-petition obligation. It's a obligation that you have to the holder of the gift card, but it arose prior to your filing of the bankruptcy. For your business reasons, you definitely will want to honor them so that you keep the goodwill of the business going. You would clearly irritate a lot of customers if they had a gift card and you said you wouldn't honor it. So courts usually allow you to honor the gift cards pre-petition. Once again, back to the Bed Bath & Beyond case, since they're going out of business, I don't know if you've noticed on their advertisements that you have to redeem all of your gift certificates and gift cards by the close of business today, or you forever can't do it. If you're an ongoing business, there'll be a longer period than just a couple of days. But the point is, it's something you owe pre-petition. You need the court to authorize you to honor those gift cards. In addition, if you have a lender who has a lien on all of your assets, which would include your receivables and your deposit accounts and inventory and the like, what is received if I owe you money for something I bought before you filed the bankruptcy, that's a pre-petition receivable. So the bank, your lender, is entitled, when I pay that, even if I pay it after you filed the bankruptcy, to get that cash. But what clients like to do, or bankrupt clients like to do, is to use that cash to operate. And so you have to go to court and get the court approval to let you use the receivable collections of your lender prior to the bankruptcy. Similarly, if the lender is going to keep lending to you, or you're getting a new lender in post bankruptcy, you just can't enter into that contract. You have to go to the court, and there are various standards for the court to approve it. So these are things you want to do first day if you can, especially the financing, because the financing is going to be the lifeblood to let you continue to operate your business, pay your employees, and other business expenses. All right. As we talked before about the utilities, if you owe them money, they can't terminate service, but 20 days after you file, you have to give them adequate assurance of payment, which is generally a cash deposit, and that can be negotiated, and then you'll deal with their arrearage at a later date. If you want to sell something, let's assume, back to the manufacturer, you have a piece of machinery or equipment that you don't need anymore. You replaced it. You need court approval to sell that piece of equipment. If you have a customer list, for instance, you're a retailer, you have a customer list, and you want to sell that customer list, you need to get court approval for that, and there are some other hoops you have to jump through to sell that. The only thing you can do in terms of sale of assets is ordinary course of business. So if you're in the business of like Bed Bath & Beyond, and they were going to stay open, they could continue to sell their inventory in the ordinary course to consumers, but they couldn't come in and say, I'm going to sell all my inventory at the Braintree store to one person. That's out of the ordinary course, and they need court approval for that. So these are all things, part of the planning stage. People will come in and they'll want to try to sell assets, but this is all planning, so you know what you have to do early in the case. In terms of getting bank financing, if you can get unsecured credit from a bank, that's great. You just give them administrative priority. And what that means is the bankruptcy code sets up a hierarchy for who gets paid before whom. And the debts you incur after you file a bankruptcy are entitled to be paid before the debts you've incurred before the bankruptcy. And so when we talk about unsecured credit with administrative priority, that would allow the bank to say, if we don't get repaid our loan by you, we're going to get paid first before any other creditors. My experience is that getting that kind of credit is unusual in a bankruptcy. Banks are going to want to get liens on the assets and be secured. And so banks can take a second lien on an asset if there's a lot of equity. If you have a piece of real estate where you have a $10,000 first mortgage and it's worth $1 million, maybe a bank would take a second mortgage on that. Or if you have, the bank has a lien on your receivables and inventory, but not on your fixed assets, they could take a lien on that because they're unencumbered. Or if you make the proper show of proof, they could obtain a first lien on the assets ahead of your existing bank. That's called a priming lien. I would say oftentimes banks don't like to get into fights with other banks. So what would happen is your new lender would pay off your old lender and take a first lien. But I have been involved. I think I was involved in the first case in Massachusetts in which we sought to have a first lien and push the existing first and second lien holders down. There are standards for that, and that's getting us into the adequate protection. And adequate protection, the concept of this is, remember, there's an automatic stay at the beginning of the case. Nobody can take action. But if you're a bank and you have a lien on the company's assets, let's assume the bank is owed $10,000 and the company's assets are worth $15,000, the bank is fully covered. And the court doesn't want to see the bank go from fully covered to not fully covered. So they will suggest that you give the bank adequate protection. So adequate protection could be that you make payments to the bank, periodic payments, so that they preserve the debt to loan to value of the collateral. Now, it doesn't have to be, if the bank's owed 10 and the collateral's worth 15, one can argue that the bank's protected because there's a $5,000 cushion, and unless that cushion disappears, the bank doesn't need anything. So $5,000 cushion usually isn't enough. But if you had, for instance, $1 million of assets and you owed somebody $10,000, the court would say, listen, you got lots of room for this thing to deteriorate and you're still going to be protected. You don't need any payments. But if you have depreciating fixed assets, for example, that are going to go down in value over the course of the proceeding, the court will want them to be protected, and you could protect them by making some payments to be negotiated or to be ordered by the court if you can't agree. You could also give them a lien. Under bankruptcy law, the lien of the lender terminates as to assets acquired after the bankruptcy. So that if I have a lien against your inventory, I have a lien on the inventory that you have in-house the day you file bankruptcy. You go out and buy inventory the next day, my lien arguably doesn't attach to that. So one thing that we commonly see is that the lender who has a lien prior to the bankruptcy will get a lien on the assets acquired after the bankruptcy. So the lender doesn't have to worry, was that receivable created beforehand? Was that inventory purchased before or after? They will just have a lien on all of the assets. And sometimes that's sufficient to protect them. And then the code has the other concept of indubitable equivalent, which is basically, think of something that's going to give them comfort. And, it may be that, you personally have a piece of real estate that's not in your company, but you're willing to give a mortgage on it, or that you're going to go out and sell assets and pay them down. I mean, there leaves to your imagination, but basically the concept is that your pre-petition lender should not be in a worse position by virtue of the bankruptcy. If it's fully protected before, it should be fully protected after. If it's not fully protected before, well, then, they're not entitled to adequate protection because they're not secured. And this ties into use of the cash as well. If you're going to use the lender's cash, like I talked about the receivable that I paid from a pre-petition sale that I paid post-petition, you want to use that cash, you have to show that the lender is going to be protected. And that's why we talk about giving them a post-petition lien to protect them on the new receivables that come up. Okay. Leases and contracts. If you file a bankruptcy, you can terminate a lease or a contract. So that if, we used the Bed Bath & Beyond example before, where they had 500 store locations and they wanted to go down to 300, they could terminate 200 of those leases in the bankruptcy. There would be the landlord would have a claim that would get paid as part of the plan, and the claim is capped under a formula in the bankruptcy code, but they could terminate that lease. Similarly, if you have a contract with somebody that you've agreed to manufacture and sell to them certain widgets, and you find that you're losing money on the contract, terminate the contract. They'll have a claim for damages, but you can terminate the contract. You can see from my slide that there are different time limits that are going to apply and the like. Now, if you want to keep the lease, let's just use the lease for example, or if you want to sell the lease, leases can be sellable, despite the fact that the lease may say it may not be assigned without the landlord's consent. In a bankruptcy, it can be sold, but you have to meet certain hurdles. So first of all, you'd have to cure the defaults. So if you were 2 months in arrears to the landlord when you filed bankruptcy, those 2 months would have to be paid. And then you would have to give adequate assurance of future performance. And what that means is the landlord wants to know that whoever is taking over this lease can perform its terms. So if if Bed Bath and Beyond has a lease that says they're going to pay $20,000 a month for the premises, and they want to sell it to me, they're going to want to know that I can pay $20,000 a month. They want to see my financial statements. They want to know my sources of financing and the like. If Bed Bath and Beyond said, I want to keep this lease, and here I'm curing your defaults, Bed Bath and Beyond would have to show the landlord or the party to the contract, I'm just talking about leases, but it applies to all contracts, that they could perform. The landlord already has Bed Bath and Beyond that's in bankruptcy. He wants to see how Bed Bath and Beyond is going to be able to pay them going forward. And, if you can't reach agreement, then the court's going to decide whether you've given the landlord sufficient assurance that you can continue to perform under the lease. If you're in a shopping center, there are additional leases, additional requirements. For example, if your shopping center says you can't sell to another drugstore because CVS is in the shopping center, you may have to comply with that. But there are other requirements for shopping center leases. But unless you terminate the lease, you have to continue to pay the rent during the pendency of the bankruptcy proceeding. So you can't just stop paying rent during bankruptcy. You're going to have to pay the landlord for every month that you're in there until you either terminate the lease or decide you're going to assume the lease. And if your landlord is bankrupt, you can keep occupying the premises and you just pay your rent. So the landlord, by terminating the lease, can't throw you out for the rest of the lease term. So there's lots of power there to deal with contracts and landlords. Now, the bankruptcy court does provide creditors with, and companies as well, but it's usually creditors that are more interested in pursuing these things, with serious remedies, because the goal is to treat everybody fairly and equally. So preference is if you give value for an old debt within 90 days prior to the bankruptcy, they can seek to recover that value. So let's say, for example, that you owed me money under a contract that was overdue, and 90 days before the bankruptcy, you said, David's a good guy, I want to make him whole, you pay me the whole amount. The bankruptcy court and the creditors can come in and force me to repay that amount because I was treated preferably within 90 days of the bankruptcy. So they're saying, David's getting a better deal than the other people who were owed money within 90 days, and we're going to be able to recoup that from David and distribute it equally amongst the creditors. There are various exceptions, which we won't go into, in various defenses, but that's something you have to beware of, that if you preferred creditors, they may be forced to pay that back. Similarly, what is known as a fraudulent transfer. If you're filing bankruptcy and you say, I have this piece of real estate here, and I really want to protect it from the bankruptcy. It's worth $1 million. I'm going to give it to my daughter for $1. The court will come in and set aside that transfer and require her to retransfer the property to the company because she got it for a bargain deal. The court does not want anybody getting bargain deals. And the time period for this can extend a year to 4 years that they can look back at this. So if you're transferring property for less than its real value for whatever reason, whether it's a gift, whether it's to protect it, whether, whatever the reason is, the court can undo that transaction. Similarly, with creditor offsets, this happens a lot with banks. You maintain a bank account with the bank. You owe the bank $100,000 before the bankruptcy. They take all the money in your deposit account and apply it to their loan so that they get out in full because you had a lot of money in the bank account. But if for some reason within the 90 days, you only had $50,000 in the bank account, so the bank was $50,000 short, the court again will say to the bank, you got to give back 50 of the 100 because you improved your position. And we're not going to let that happen because we're trying to treat everybody equally. So these are things that, you as a company, will be probably expected by the creditors to pursue these actions, absent which they'll pursue them. But you do have relationships here, and the relationships, the reason you gave somebody a preferred payment was because he was a good guy or whatever it may be. But your relationships have to know that, by doing these things, they could be subject to court litigation. Okay. Now, there are various chapters under the bankruptcy code. Chapter 7, which we'll talk about at the end, is liquidation. That's basically you're going out of business and you're just going to sell all your assets and pay your creditors to the extent that you can, and you're done. Chapter 11, which we're spending most of our time on, and a lot of what we've talked about applies both in Chapter 11 and Chapter 7. But Chapter 11, you're trying to reorganize the business, although Chapter 11 can be used as a way to liquidate the business, as Bed Bath & Beyond is doing there in Chapter 11, not Chapter 7. But generally, Chapter 11 is looking to reorganize the business. There are other chapters for municipalities and the like. The other chapter you may hear of is Chapter 13, which is for individuals to reorganize. We're not going to deal with that here. We're focusing on businesses, not individuals, but there is a whole chapter talking about an individual who's run into financial difficulty can file a bankruptcy and reorganize and term out its obligations. So Chapter 11, which is the reorganization process, which hopefully would be where you file rather than liquidation. A few years ago, Congress enacted a separate section for small businesses having debts of less than 2,725, and that number can increase. During COVID, it increased to 7.5 million, but that went away. Chapter 11 is a process in which you file a bankruptcy, you stop the creditors from pursuing actions, you borrow your money or use your money to run your business, and then you have to come up with a plan at the end of the day in which you say, this is how I'm going to deal with all of my creditors. And if the plan is approved, you come out of bankruptcy and run your business and pay in accordance with that plan, your old debts. There are a lot of different players that get involved in a Chapter 11. You'll have your attorneys. There'll be a United States trustee, which is sort of like an overseer from the federal government that comes in and has a say in the court. You have the judge, and in many cases, you'll have a creditors committee. They'll get the largest creditors will come together, and there'll be sort of a steering committee for the creditors body, and they'll hire their own attorneys and their own accountants. And you'll have to negotiate with them if you want to, sell that piece of equipment you don't need, and you want to sell it for $1,000, and they say, no, that's not the way to go, or whatever it may be. They're going to be involved in all of the decisions. So it's going to cost, and the bad news is you pay the freight for all of their professionals as well as your own professionals. So the creditors committee can be helpful, but it can also be something that causes you to delay what you want to do or prohibit what you want to do. If you're a small business, though, as we talked about before, there's no creditors committee. So the creditors aren't going to form a committee. They're not going to have that same approach. They're trying to make this case easier and quicker for small businesses. Similarly, just to touch quickly on the others, if there is a reason, the court can appoint somebody else to either run your business in a Chapter 11 if you're really not running it well, and that's a much higher standard than not running it well, or to investigate operations to see if you've done anything inappropriate. Again, these people are appointed by the court, and you'll pay the freight for them. But in a small business case, these people aren't going to be appointed. All right. Your plan of reorganization that we talked about that you have to file within 120 days if it's not a small business case. Small business cases, they want it to move quicker, so you have to file it within 90 days. But the benefit in a larger case, you have to file a disclosure statement, which is basically an SEC-like document where you talk about the history of the business, your financial results, why you're in bankruptcy, what you hope to achieve, what your financial projections are. That takes a long time, and that has to be approved by the court, and it's really a big effort. In a small case, you don't have to do that. Once again, the courts are trying to simplify it. The contents of a plan, there are many more requirements in a large, I'll distinguish between large and small business case. And you see in the small business case, they're paired back to you give a brief history. What happens if you don't reorganize and you just liquidate the business? Your projections as to how you're going to pay in the future, and your agreement to use your earnings to pay the debts. Much simpler, much less to prove, much less for the court or the creditors to come in and upset the plan. Confirmation of the plan in a large bankruptcy comes. First, you have to file your disclosure statement, have it approved by the court, and then you send the plan and the disclosure out to creditors. They have a chance to review it and come in and object, and you need 2/3 in amount and half in number of the creditors to approve it, or you have to go through a cram down, which really means you have to go to the court and show the court why your plan should be approved, even though you don't have the requisite creditor approval. There are standards set forth in the code for how you can cram somebody down, but absolute priority rules. What absolute priority and briefly is that if you're an owner of a business, all of your creditors have to get paid before you see a dime. If you're an unsecured creditor, the secured creditors have to be paid before you see a dime. So it is a hierarchy of payments that has to be met. And whereas in a small business case, administrative claims, remember, administrative claims are amounts you incur during the bankruptcy. Generally, in a large case, those are paid on confirmation, upfront, lump sum. But here, in a small case, they let you pay them over time, and the standards for approving the plan are a lot easier than in a large case. Okay. In a small business case, you have to file your tax returns, balance sheet, cash flows, periodic reports, maintain insurance, and attend meeting with creditors. As you can see, there's a lot of time and effort that goes into bankruptcy. So when I said at the beginning, it should be the last resort, it should be, because it's going to not only cost you money, it's going to divert your attention, cost you time. I know, somebody personally right now who's works for a company in bankruptcy, and she's spending day after day in depositions and litigation about how the company handled something. And so she can't do her normal day job. She has to do this. It's going to really take attention away. But the benefit of it is, if you have a viable business and you just have a reason why there's a hiccup and you can turn it around, you can turn it around and deal with your creditors and keep the business. So, and you'll see in the top bullet point here about absolute priority rule inapplicable, so debtors may retain equity. Remember, I said absolute priority. If you own the company, you can't get anything unless all of the creditors are paid. In a small business plan, you can, as long as you make the payments and can make the payments. You can keep your equity. In a large case, to keep your equity, sometimes you have to basically invest more money, infuse more capital into the company so that you can keep your stock. You have to give value to keep your stock. In this case, you don't have to. Okay. Briefly talking chapter 7. In a chapter 7, A third party is appointed to liquidate the assets, do investigations, commence those actions for preferences, fraudulent conveyances, and distribute the proceeds in order of priority. Your obligation in Chapter 7 is just to give information, be available for meetings and discussions. The schedules and statement of affairs, we talked briefly about that before. What that is the schedules will list all of your assets and liabilities. The statement of affairs will answer questions about, have you made any preferential transfers? Have you given any fraudulent conveyances? And many other questions. Trustees in Chapter 7 can, but generally don't operate the business. So they're just there to close it up and collect as much money as they can, not just from the assets, but from all the avoidance proceedings. What I found when I was practicing is the trustee would send a letter to everybody who got a payment 90 days before bankruptcy and say, this is preferential, you got to return it. Now, they weren't all preferential. It was the trustee just trying to shake some money out of people, but some of them were preferential, and the trustee got to collect them and use the money to pay the creditors. So the trustee gets paid. You're basically out of the picture here. And in Chapter 7, in Chapter 11, as I said, you can be in control, but you're going to have creditors committees, you're going to have the U.S. trustee, and if you're really badly maladministering the case, they could appoint a trustee or an examiner to come in and watch over your shoulders and or operate the business. It's a lot of material, which I've touched on briefly because we only have an hour. It's really pretty complicated, and you do need legal help to do this. But the key thing is plan, and work with people before the bankruptcy, as we talked about here in the pre-bankruptcy planning. So let's turn, Teresa, do you have some questions there?
Yes, we do have some questions. Can you guesstimate how much of a budget do you need for a bankruptcy?
That's going to depend on the size of the company.
Okay.
And the difficulty of the case. I mean, obviously, when I was involved, and I just keep picking Circuit City because that's the one name that comes to mind, but I could pick KB Toys, I could pick Service Merchandise, I could pick lots of names. They were big national companies with lots of locations, and they probably spent millions and millions of dollars just on their own attorney's fees. In a small business bankruptcy, you're not going to have that kind of legal fee. And if you're a small business, you're not going to have a creditors committee to pay, and so on and so forth. But, if you look at your utility bills, figure anywhere from 2 to 6 months of utility bills for a deposit, possibly. Your attorney, he'll tell you how much it's going to be, but, I would bet that in a lot of these cases, you're talking low 5 figures, at the outset, and depending on what happens, what litigation there is, you can never tell. But and some of these costs will be offset by things you're not paying in the bankruptcy. Like you're 4 months behind in your landlord, you're not going to make up those 4 months right away. And coming out of the bankruptcy, you need to be able to show that you're going to generate enough revenues in order to pay whatever you've agreed to pay in the plan. And in the bankruptcy, you have to show you have enough revenues to pay your debts that you incur from the date you file the plan forward. So it's going to vary from business to business. I mean, if you're a small, business that does $25, $50, $75, $100,000 of revenues a year, it's going to be a much smaller budget than, if you're a much larger company.
Okay. What if you have an SBA loan that you are personally liable for paying if the company is unable to do so? How is this type of loan in this situation handled during bankruptcy?
Well, if you have a personal guarantee, as I said, the SBA could come after you on your personal guarantee despite the business bankruptcy. The SBA generally takes a lien on all of your business assets. So that would come back to my adequate protection discussion, which is how much is the SBA owed by the business, and what are the value of the assets that secure its lien. I have a case presently that I'm consulting on, where the SBA has, I'll just make up a number, $100,000 loan, and the value of the assets of the business is probably $15,000. So they're not going to be entitled to adequate protection. You're not going to need to make principal or interest payments to them during the bankruptcy. And at the end of the bankruptcy, how are you going to handle their claim? If their collateral is worth $15,000, you will have to pay the SBA $15,000 at a current market rate of interest over time, usually up to 5 years. What happens to the other $85,000 in this case? In this case, the other $85,000, the SBA could either say, I want that $85,000 to continue to be secured by the lien. So the lien would be for $100,000, but you're only paying it based upon $15,000. And the reason they do that is they think, maybe you'll sell the business and they'll get out in full if you sell the business. Maybe, the business is such that it's rather than an asset-based business, it's cash flow, which is you provide, legal services, for example. And so you don't have assets, but you have a lot of, cash flow coming in, and they'll say, I want to keep my lien in case you sell the business. Alternatively, the $85,000 will be treated the same way as other unsecured creditors. And that would mean that if you're paying other unsecured creditors 10 cents on the dollar, the SBA will get 10 cents on that $85,000. It'll be payable per your plan. It could be all payable up front. It could be that you pay that, 10 cents over time, depending on what your plan is. Beyond that, I mean, obviously, if the SBA's $15,000 of collateral is depreciating, you'll have to pay adequate protection on that. But assuming that it retains its value, then you're not paying adequate protection in the bankruptcy. All that being said, the SBA could still sue you for the $100,000 personally, could seek, a lot of SBA loans, not only do you personally guarantee, they have a mortgage on your residence. They could seek to foreclose the mortgage on your residence despite the bankruptcy. So, you personally may need to file bankruptcy as well to stop the SBA from taking action. Or you could try in your bankruptcy to say, listen, Judge, to make this business bankruptcy successful, I need to devote my time to it. And with the SBA hounding me in a lawsuit and foreclosure of my home, it's just diverting from the success of this. And the judge may, and I use the word may, not that it's a likely thing, but the judge may say, you're right. You need to focus on the business. SBA is not going to hurt you if you just sit back for 6 months or in a small business 90 days and do nothing. But if you don't get the court in your business bankruptcy to stop the SBA from going after you personally, which is not a common occurrence, by the way, getting that kind of relief, then you're going to have to think about negotiating with the SBA some sort of payment plan on your personal side, or filing a bankruptcy yourself, or just letting them foreclose on the real estate.
Okay. How does a bankruptcy case start under one chapter and then convert to another chapter? Who decides? The debtors, the creditors, the court?
All of the above. The usual conversion is from Chapter 11 to Chapter 7 liquidation. The creditors can file a motion with the court seeking to convert the case on the basis that there's no likelihood of a plan of reorganization, no likelihood of success in the chapter proceeding. The debtor who files the Chapter 11 can at some point say, you know what, this is going to be a liquidation. I want to convert it to a Chapter 7. Both of those conversions will have to be run by the court, and the court will have to approve them. But basically, the creditors or the debtor can convert them. And at that point, it's you have like a new case. Now you have a Chapter 7 case. And how are you going to deal with the Chapter 11 expenses? They'll be treated as administrative expense and so on and so forth. But basically, the debtor or the creditors will convert it. The court can convert it on its own as well. As I said, you have to pay your post-petition bills in a Chapter 11. And if the court's finding that you've run up $100,000 of debt and you're not paying it and it's becoming past due, the court could say, listen, this is not going to be an 11 reorganization. I'm going to put it into convert it to a Chapter 7. But generally, it's done either on the request of the company or the request of the creditors.
Okay. If I operate my small business as an S corporation, is the bankruptcy essentially a personal bankruptcy and not a small business bankruptcy?
The answer is no. It is a small business bankruptcy. The S corporation designation is for IRS income tax purposes only. An S corporation, let's just assume you formed it in Massachusetts, it is a Massachusetts corporation. If you have debts of less than that 2.7 number, you can file a small business bankruptcy. The only thing that the subchapter S election does is, for federal tax purposes, allows the profits or losses of the business to flow through to the individual owners. So the business doesn't pay taxes the individual owners. It's sort of like a limited liability company. If you form a limited liability company, at the end of the year, the profits or losses are reported on the individual owner's tax returns based upon their percentage of ownership. It's the same thing with an S corporation. The profits or losses at the end of the year reported on the individual owner's tax returns. It has nothing to do with whether you can file a small business bankruptcy. You're a corporation, you have debts of less than the number, you can file a bankruptcy. Doesn't relate to subchapter S election at all.
Okay. I don't have any currently posted questions. We do have time for maybe one or two more questions. If anyone wants to type something in real quick, or do the raised hand icon and I can unmute you so you can ask your question. If you find you have questions after this presentation, I certainly encourage you to go to the score.org website and put in a request for mentoring. There are mentors out there, including David, that can answer those questions for you. You can set up an appointment with them to ask all the questions that you might have, and they can go into a little bit more specifics.
Right. I mean, it's going to be very specific to your business. Presently I'm counseling somebody who has a business that is having cash flow difficulties, and we're just trying to work with the business to get it to a point where it can be sold for a reasonable price. The initial part of the discussion when I first met the client was, I think I need to file bankruptcy. And when we went through all the points I went through today, and the company does not have a lot of past due debts, so the bankruptcy won't keep creditors off the company's back because there are no creditors on their back. The company needs its location to operate, so it doesn't want to terminate its lease. And we went through all these factors and we came to the conclusion that bankruptcy wasn't a good idea. We should try to work this out outside of bankruptcy. And so absolutely, I'm available. I'm sure there are others available. My fondest hope is that none of you ever have to talk to me about bankruptcy. Talk to me about other things. But if your business is in distress, I'm more than happy to help you. I mean, I worked with representing lenders with distressed businesses, and I worked with distressed businesses working with lenders and other creditors. So whichever way, we seem to have a question now.
Yeah, and this will probably be our last question for today. When you file a Chapter 11 small business bankruptcy and you have personally guaranteed the loans, how do you avoid the personal bankruptcy?
I think early on, I said that one of the pre-bankruptcy steps should be talking to your lender. And that's the best way to avoid the personal bankruptcy, is to talk to your lender, explain to them what's going on, seek out their cooperation, both for the business and for you personally. And that's, I find, the best way is through open discussion and negotiation. Now, if that doesn't mean the lender is always receptive to that. And if the lender says I'm going forward no matter what, some clients have had defenses against the bank, that the bank promised, for instance, to lend them $50,000 and only gave them $25,000. So, they bring a lawsuit in the court to stop the bank's foreclosure on some basis. You have to have a basis to stop the bank's foreclosure or the lender's foreclosure. But a lot of times people will bring lawsuits in the state courts against the banks or the lenders and say, you should be stopped from foreclosing because you acted badly, and they lay out the reasons. So before you file bankruptcy, you can try a state court proceeding. Of course, that's going to cost you money too, and time and legal fees, and you have to have a case. You just can't file a case saying, I don't want you to foreclose. You have to have a reason why the bank should not proceed against you. But I would say that the successful cases were the clients that came to the bank and said, I'm having financial difficulties. I don't know how we're going to do this. I've talked, and come in with your attorney and say, I've talked to Mr. Attorney here, and he thinks I can do a reorganization of the bankruptcy. I'm not asking you to, release me from my guarantee. I just ask you to give me time to try to work this through. And then if it doesn't work through, we'll work something out. And the way that it got worked out, even if the business didn't work out, if you come to the bank with a presentation and say, okay, the business failed, I still owe you $85,000. I haven't got $85,000 cash to pay you. I don't want you to foreclose on my house. Let's, I'll pay you out over 3 years in monthly payments of this. And banks are receptive to that.
Okay. There is one more question in chat, if we can maybe grab that one. Franchise owner that has revenues below the 2.7 mil mark, that is an LLC. My business was greatly impacted by the pandemic, and I'm having trouble paying the royalties. Does this complicate things?
I'm sure that the franchisor has the ability to terminate your franchise if you haven't paid the royalties. Now, that being said, if you were to file bankruptcy, the past due royalties would be treated as past due. You could terminate or not terminate the franchise agreement as you saw fit. It sounds like you want to retain the franchise agreement. And if that's the case, you'll just have to pay the franchisor what is due during the bankruptcy. Hopefully, some of the other savings in the bankruptcy, in terms of not having other creditors who owe you money hounding you, will help you formulate a cash flow that can pay the franchisor the fees. But if you can't comply with the franchise agreement of the bankruptcy, the court may allow the franchisor to terminate it. So the key there would be to file the bankruptcy before the franchisor terminates, so that you still have a franchise agreement, because if he's terminated it, you won't have the franchise agreement, and deal with it in the bankruptcy. But the franchisor could arguably, just like the landlord could terminate your lease for non-payment of rent, the franchisor can terminate your franchise agreement for non-payment of fees. Now, that being said, the landlord may have another tenant willing to move in. The franchisor may like the territory you're in, may not want to give up the franchise, and therefore, will want to work with you to work something out. So it's not just a automatic, I want to blow this up thing with the franchisor, because they're doing a franchise for a reason other than taking your initial whatever it was you paid for the franchise and the like. The franchisor wants to be in this marketplace, and I think that that's something to consider.
Okay.
No other debt. No other debt other than royalty obligations. Right. Just 1 second. Let me just read the chat comment on that. My business is greater than all right. I have no debt other than royalty obligations. Oh, absolutely. Selling would be a better option. As I said, bankruptcy is always the last option. You could approach the franchisor and say, listen, you're in the process of selling the franchise. You'll pay them what you can until, because the franchisor will have rights under its franchise agreement, if it's drafted as most franchise agreements are, to approve who you sell the franchise to. So it's good to keep them involved. Tell them this is the process you're going through. You're finding it a little tough. You're looking to sell the business. You know, the franchisor in some cases may say, I'll buy it back from you. Or they'll, you know, just sit tight and give you some time to try to sell it. So yeah, I agree. A sale would be much better than a bankruptcy here.
Okay. All right. Well, we're going to wrap that up for today. Thanks, David, for sharing all your knowledge. I know you've got a lot to share, so we greatly appreciate that. Thank you for all those that attended today, and I hope you guys all have a great rest of your week. Thanks.